So, I guess I probably should apologise first to those people who, like me, do find these motions to be a little bit boring. However, I am going to read through each motion because for me to fully understand them, I need to read through them anyway. And I figure that by reading through them, hopefully you guys can pick up where I miss off. In other words, I'm not sure that I'm fully interpreting all these correctly because there's so much legal speak in here and so much jargon that I would rather be sharing these with people rather than just giving my summary, which could be incorrect. So this is the second video of me going through the 52 motions that Stearns' lawyer has submitted in the past 3 or 4 days. And as you've probably guessed by now, the gist of them is basically to try and get rid of the death penalty and also to try and silence Maddie's voice, essentially. They don't want the jurors to feel sympathy for Maddie. They don't want the jurors to feel sympathy for the people that Maddie have left behind, the other victims in this case. They do want the jury to feel sympathy for Stearns' parents, and we'll get to that in one of the documents. So, with that said, I'm just going to jump in and muddle on through with these documents. Yes, that is my aircon and evaporative cooler running in the background. We're going through a never-ending heatwave here in Australia, which is just so not fun. So I apologise for that background noise. Now, I should also mention that all these documents have been uploaded to my Patreon. So if you want copies of these, just hop over, join my Patreon. It's free, and the documents are free to upload. You may... there is a $1 and a $2 tier on my Patreon, but there's no requirement for you to be a paid member to get these documents. Those tiers are simply for people who wish to support my channel in just a small way. And for those people who do, I greatly appreciate it. For those people who just want to be free members, I also greatly appreciate you. So the link for my Patreon will be below this video in the description section so that you can hop over and grab any documents that you want. There's quite a long list there now. So with that said, let's jump in and start having a look at these documents. You know, I'm really looking forward to hearing what the judge has to say about all these motions. Here we have a preemptive motion, which just seems a little bit ridiculous. Motion to preclude the state from alleging discovery violations. Comes now the undersigned counsel for the defendant and moves this honourable court to enter its order precluding the state from alleging discovery violations related to undersigned counsel's investigative strategies. In support of this motion, the defence provides the following. And then we get the usual thing from the counsel or from the defence, where they are basically going to show a whole bunch of quite possibly irrelevant precedents. In the case of State versus Florida, the Ninth Judicial Circuit moved for the court to consider sanctions against defence counsel to support its allegation that defence counsel intentionally withheld discovery in violation of its obligation to disclose reports of experts intended to be called to testify at trial pursuant to Florida Rule Criminal Procedure 3.220. The state referenced a prior incident in this case, in which petitioner's counsel had informed a different witness that the defence did not need her to author and create a report concerning her findings blah blah blah. The state alleged in its motion that defence counsel had directed Dr. Walsh Haney not to author a report intentionally, unethically, and in violation of a prior court order to gain a strategic advantage in the case. Okay, I think I can see where they're headed here. Here, the defendant's investigation is ongoing and is still in its nascent stages. However, the undersigned counsel's experience on working many first-degree murder cases, it is not uncommon for defence counsel to request that their experts refrain from writing reports. Well, that seems a little odd to me. Whether an expert writes a report, reviews certain materials, communicates with the defendant, etc., is all within the sound discretion of the defence attorney. There is absolutely no discovery obligation within Florida Rule of Criminal Procedure that requires a defence attorney to have a testifying expert draft a report. Further, the drafting of a report can be cost prohibitive, adding several $1,000s to the expert's fees. Florida Rule of Criminal Procedure specifically addresses mental mitigation and requires that a notice of intent to present expert testimony of mental mitigation be filed no less than 20 days before trial. It further states the notice shall contain a statement of particulars listing the statutory and non-statutory mental mitigating circumstances the defendant expects to establish through expert testimony and the names and addresses of mental health experts by whom the defendant expects to establish mental mitigation, insofar as is possible. Should a mental health expert or experts be utilised in this case, the state will receive notice and have the opportunity to depose such experts at the appropriate time. There is no authority for the Office of the State Attorney to direct the defendant's independent investigation. Wherefore, the defence respectfully moves His Honourable Court to enter its order precluding the state from raising discovery violations should the defence rely on a mental health expert that is directed not to write a report. Bingo. So from this it sounds like they're planning on using the TBI argument. They're going to argue mental health for Stearns, and they don't want a written report that will allow the prosecution to go through it with a fine-tooth comb. They simply want to provide the prosecution with facts, give them the name of the person who's done the assessment, and allow the prosecution to depose that person. Now, here's where I think things could be tricky, because if a report is written, then that report would have to be available through discovery. But if a mental health professional has done an assessment of Stearns, couldn't they refrain from giving information to the prosecution and claim patient-doctor confidentiality? So basically, I think what's happening here is the prosecution, the defence, are trying to prevent the prosecution from having too much information about their defence of mental health for Stearns. They basically want the prosecution to have to question this witness on the fly, by the sounds of it. It will be interesting to see how the judge rules in this one, but I would imagine that hopefully the judge is seeing through all this crap that this person is putting in and will rule that there should be a report submitted. Now, looking at this next document, I'm going to take a guess that, particularly given the length of this document, A lot of this document is going to cite precedent, it's going to cite textbooks, it's going to cite speeches. A lot of that stuff I'm just going to skip through because it's just so tedious. So this motion is to preclude the death penalty as a sentencing option. Comes now the defendant through the undersigned and pursuant to the 5th, 6th, 8th, 14th Amendments to the United States Constitution, yada yada, moves the court to preclude the death penalty as a sentencing option, and in support thereof would show the court the following. Death is different. Well, that's profound. Stephen Stearns has been indicted by the state for first-degree murder. The state is seeking the death penalty. The 8th Amendment to the United States Constitution requires a greater degree of accuracy in fact-finding that would be true in a non-capital case. Well, yeah. Because the right to life is a fundamental right which must be subject to at least the same constitutional protections as the right to vote, the state must establish safeguards to ensure that it does not treat its citizens in a disparate and arbitrary manner with respect to their lives. If anything, courts must require more safeguards to ensure the equal treatment of all persons in the context of death penalty prosecutions than in that of an election recount. That's a really poor argument. Whereas the right to vote is fundamental because of historical trends and legislative decisions, the right to life that is at stake in Florida's system of capital punishment is the most fundamental of all rights, and accordingly it's found in the very context of the Constitution. So now they're going to cite a whole bunch of things. Bush versus Gore, the Supreme Court recognised that the right to vote is not contained in the text of the Constitution. The individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as through the means. Why quote this? In contrast to the implied right to vote, the right to life is contained in the text of the Constitution. The 5th and 14th Amendments provide that neither the federal government nor the states shall deprive any person of life, liberty, or property without due process of law. Well, that's what this whole case is about, due process of law. The Supreme Court has long recognised the fundamental nature of the right to life, particularly in the context of the death penalty. Yes, okay, but it still allows it to happen. The state needs a compelling interest to justify it. Because the right to life is fundamental, when a state implements a death penalty system, it must establish mechanisms to ensure that the system values the lives of its citizens equally. As the Supreme Court noted with respect to voting, having once granted the right to vote on equal terms, the state may not. Why bring up the voting thing again? These are apples and oranges. This sounds like it's some argument out of a right to life paper. I'm sorry. I know I'm usually better at holding my tongue with things like this, but I just think that they're grasping at straws a little bit here. Okay, by the same reasoning, since the Constitution has ensured the right to life and to the equal protection of the laws, a state may not, by arbitrary and disparate treatment, value one person's life over that of another. Well, I'm sorry, but what about Maddie's life? Who values her life? Because Stephen didn't. So the moment, as far as I'm concerned, the moment he decided that he did not value her life, then that diminished the value of his own life. In the brief period since Bush was handed down, several commentators have taken notice of this result. And she's going to quote a whole bunch of people now. So, if a state or its courts cannot arbitrarily dilute a person's right to vote because of the Equal Protection Clause, then human life must also be given equal protection. Now, in Australia, there are conditions by which people lose their right to vote. Does that not also happen in the US? I'm curious. Because if you can remove people's right to vote because they have received a criminal conviction, for example, then why can't you remove a person's right to life if they have taken another person's life? Noting the Bush holding might require that methods be in place to ensure against the differential treatment of those subject to capital punishment. Florida's lack of standards to ensure non-arbitrary treatment with regard to the fundamental right to life is enough in itself to establish an equal protection violation. A showing of intentional discrimination against a protected class is not required. While in traditional claims of discrimination against individuals, courts require evidence of discriminatory intent by a state actor in that particular case. Equal protection claims of intentional discrimination against a protected class, claims like this one and the one in Bush, are not based on an individual act of discrimination, but rather challenge a system in which uncontrolled official discretion makes arbitrary and unequal treatment inevitable. The Florida death penalty prosecution system must be subject to the same equal protection constraints as the Florida recount. If the Equal Protection Clause requires rules to ensure that localities do not treat identical types of ballots used in identical brands of machines and exhibiting identical physical characteristics differently, what a ridiculous argument. I'm really not getting this at all. Now, given the length of this particular document, I know I said that I was going to read through all these documents, but it seems like they're just making the same argument over and over, that if there is a need for equality with voting, then there's a need for equality with the death penalty, and therefore Stearns should not be subjected to the death penalty. Like I said, apples and oranges. If I go to Aldi later today, then I can get apples way cheaper than oranges. I know this sounds like a really simple thing to say, but most of the apples available at Aldi come from Victoria or Tasmania, so that haven't been transported far. In terms of oranges, well, they're going to come from up north, probably up in the Golden Valley or somewhere like that. Or perhaps they might be imported from California. They're going to be more expensive than my apples. So I'm not going to walk into Aldi and expect to pay the same price for apples and oranges. So to turn around and say that the law should be identical in terms of voting rights as opposed to death penalty rights, you're talking about two entirely different things. So, yeah, I'm not going to read through this entire document because I think, based on the documents that I've read before, they're just going to repeat themselves for, I think it's 17 pages. Just saying the same thing over and over again, quoting different sources, or repeatedly quoting this Bush source when they really haven't got a solid argument, in my opinion. I'll skip to the final page because usually the paragraph there will give us some idea of what the conclusion actually is. Okay, I was wrong. This one was 20 pages long. So, like I said, if you want to read it in full, you can actually find it on my Patreon. But having just skimmed through it, it is basically repeating the same thing over and over again. So I'll just read the last couple of paragraphs here. It would run afoul of the Eighth Amendment requirement of individualised consideration of each offender and the related prohibition against unduly harsh and unworkably rigid mandatory death penalty statutes. More precedent and stuff. Yada yada yada. While the reasoning in Holmes and Hornsby and the alternate holding in Nemotko have been widely followed, their support for the reasoning in Bush versus Gore reinforces the validity of that case's reasoning and underlines the fact that a system of unfettered discretion, like Florida's standardless system for deciding whether to seek the death penalty in capital cases, violates the Equal Protection Clause. Wherefore, the defendant requests the court to grant this motion. Failure to do so violates the defendant's rights under Articles 1 or I, Sections 2, 9, 16, 17, 22 of the Florida Constitution and or the 5th, 6th, 8th and 14th Amendments to the United States Constitution. Wow, she's really trying to push it there. Now, can we just recognise here that if the judge were to allow this motion to pass, they would essentially be saying that all other death penalty cases in Florida are or have been unconstitutional. So no judge is going to pass this motion because they would basically be freeing anyone who's on death row in Florida, for starters, and shooting down any future death penalty cases. So she's very definitely grasping at straws here. Let's have a look and see what the next motion is. Okay, so the next motion is a motion to preclude submission of the indictment in any form to the jury. So you don't want the jury to know what he's been indicted for? Oh, hi, jury. You're here to vote whether this guy is guilty or not. But we're not going to tell you what he did. I'm sorry, am I misreading this? Let's see what it says. Comes now Stephen Stearns through undersigned counsel, yada yada. Pursuant to 5th, 6th, all these amendments, all these sections of the Florida Constitution, to preclude submission of the indictment to the jury, in this case in any form, in support of his motion, the defence states. On April 24th, 2024, the defendant was indicted for first-degree murder. The trial court, in the course of jury selection, references to the indictment generally, and on occasions reads from it. This is not necessary and is prejudicial. Sorry. Please tell me that I'm tripping out right now. Don't the jury need to know why they're there? Moreover, the Eighth Amendment requires a greater degree of accuracy and procedural safeguards that would be true in a non-capital case. I swear to God, these people have got Kool-Aid in their water coolers. An indictment is not proof that a person committed an offence. It is therefore irrelevant to the jury's inquiry. Wherefore the defendant moves to preclude any reference by the state or the court to the indictment or the findings of the grand jury. Right. Well, given that the indictment is for capital murder, I think the jury probably do need to know that before the trial begins, so that they know what they are there for, and also so they can exclude themselves if they are someone who is dead set against the death penalty. Okay. Now this motion made me so furious. Motion to exclude evidence or argument designed to create sympathy for the deceased or vilify Mr. Stearns. In other words, we can't tell the jury anything nice about Maddie. We can't tell the jury that Maddie went through probably 7 years of hell from this monster. And we can't actually mention that this guy did anything bad, because that might vilify him. Honestly. Comes now the defendant, Stephen Stearns, through his undersigned counsel, and respectfully moves his honourable court to prohibit evidence or argument during both the guilt and penalty phase that is designed, presented for the intent of, or would have the effect of creating sympathy for the deceased or vilifying Mr. Stearns. Such evidence and argument are contemplated to include, but may not be limited to, that which details the impact of the offence on the friends and or family of the deceased. Well, there go your victim statements. The impact of the offence on the community, the life histories of the deceased, or any personal characteristics of the deceased or of Mr. Stearns. In support of this motion, the defendant provides the following. Mr. Stearns is charged by indictment filed on April 24th with first-degree murder. The state filed a notice of intent to seek death June 7th, 2024. Florida law has consistently held that evidence designed to create sympathy for the deceased is inadmissible in the guilt-innocence phase. I'm pretty certain that it doesn't say it in that form. So I'm just going to say here and now, and I don't normally like being rude, but to those people who came at me for criticising the defence lawyer and basically said it's not my right to criticise her or say nasty things about her, I'm sorry, but when I see motions like this, when I see her filing 52 motions, that is excessive, that is a waste of money, and it is basically, as far as I'm concerned, an attack on the victim. So, I will say what I feel about this defence lawyer, and I'm sorry for anyone who feels that my negativity is unfair towards this lawyer who is just doing her job. Because, yes, she's just doing her job, and I recognise that, sure, the more filings she makes before the case goes to trial, then the better chance there is of him not being able to appeal the case afterwards. But I'm sorry, most of these motions go beyond what is decent, in my opinion. This one is just the tip of the iceberg. Wait till we get to the one where basically the jury has to listen, or they want the jury to listen to the impact that it would have on his parents for him to be executed. So we can't show sympathy for Maddie. We can't vilify Stearns. But a decision on the death penalty should be based on how it's going to affect his parents. Where's Maddie's rights in all this? I'm sorry if I'm cranky, but this just makes me so wild. Okay, apologies, I've just realised that I was having issues with my microphone. I think I've fixed it. Touch wood. Okay, getting on with it. Florida law has consistently prohibited such evidence in the guilt-innocence phase of any trial. Capital or likewise, this type of evidence, along with evidence designed to vilify the defendant, is offered only to inflame the passions and emotions of the jury and encourage a jury to make findings and decisions based on emotions rather than a logical evaluation of the evidence presented at trial. Such evidence is not relevant to any issue in the guilt-innocence phase. It is virtually always highly inflammatory and prejudicial, outweighing any possible probative value it may have. See Florida Statute 90.403. The admission of such evidence would violate the defendant's fundamental rights pursuant to Article I, 2, 9, 16, 17 of the Florida Constitution and the 5th, 6th, 8th and 14th Amendments to the United States Constitution. 4. Likewise, the admission of evidence concerning the deceased or the circumstances of the offence is inadmissible under Florida law at the penalty phase or sentencing phase. Florida statute specifically limits the prosecution to the aggravating circumstances listed in the statute. None of these aggravating circumstances are related to the character or personal characteristics of the deceased or the impact of the death on the friends and family of the deceased. Yep, so, let's just throw out all the impact statements as well. Why not? Let's not tell the jury anything about Maddie. Not tell the jury anything about what she endured for all those years. Because we wouldn't want them to have a bad opinion of Stefan now, would we? This is just a load of hogwash, honestly. The Florida Supreme Court has recognised the statutory limit on the aggravating circumstances forbids the introduction of this kind of evidence. I'm pretty certain that she's basically misinterpreting something here. Florida's death penalty statute, section 421, limits the aggravating circumstances on which a sentence of death may be imposed to the circumstances listed in the statute. The impact of the murder on family members and friends is not one of the aggravating circumstances. Right. Which would not be an appropriate circumstance on which to base a death sentence. Okay, but they want to use the parents for mitigating circumstances. I'm just going to say here, I've done a little bit of research into the judge, and he has a very long career behind him, and basically he is an expert on the law. He knows statute inside out and back to front, so none of this is going to fly with him, and I really hope that this does get him offside, and basically that he sits this whole team on their ass, basically. The Florida Supreme Court has specifically disapproved the introduction of this kind of evidence before the judge alone. Florida statute does not allow this type of evidence in capital cases, although this statute allows the victim or next of kin to speak at sentencing. The Florida Supreme Court has specifically held in Grossman Supra that this statute does not apply to capital cases. The court stated accordingly, we hold that the provisions of Section 921 are invalid insofar as they permit the introduction of victim impact evidence as an aggravating factor in death sentencing. The prosecution may attempt to argue that Payne v. Tennessee somehow authorises the introduction of this type of evidence. First, Payne deals only with whether the 8th Amendment bars victim impact evidence during the penalty phase of a capital trial. There is nothing in the opinion that indicates that the admission of such evidence in the guilt-innocence phase would not violate the due process clause of the 14th Amendment. So basically now they're going to argue that any other precedents that actually support what they're trying to have struck are wrong. I'm not going to bore you and insult you by continuing to read this motion. I think we've got the gist of it. Basically, they don't want the prosecution to say anything that would elicit sympathy from the jury for Maddie, for the people who have been left behind, the victims of this crime, Maddie's best friends, these 13, 14-year-old children whose lives are forever changed by the loss of their friends. It's not something that you ever get over. Sure, we can forget about Jen, but I think we can be quite confident that it has affected Juan, it has affected Stephanie. But according to the defence, the jury shouldn't know this. And they claim that there is precedent for it. Like I said, this judge, it's not his first rodeo. I am going to do a video talking about him specifically down the track. But just, I feel confident from having researched him that he's just going to look at these motions and just toss them out. These motions are such a dry, heavy read, I have to say. So this is the second video now where I've read through motions or parts of motions. I'm leaning towards simply going through the title pages with you of the remaining motions rather than continuing to try and read through the gibberish, the legal gibberish. I know I said at the start of this video that I wanted to, I have to read through each of the motions anyway to try and understand them, and that I might as well read them through with you guys. But I am bored with these motions. If I'm bored with these motions, you guys are probably bored with these motions too. So I think it's a better use of all our time if I basically pull together the cover pages, I guess you could say, for each of the remaining motions and just do a quick summary of each. Like I said, these are all in my Patreon for free for anyone who wishes to download them. I guess I'm just a little bit tired of reading this stuff from the defence because it just feels so heartbreaking to see them wanting to silence Maddie's voice. And that's what I'm reading in a lot of these motions. Now, I know that the judge is going to throw these motions out. And so it's ridiculous me having this emotional response to these motions. But at the same time, we've learnt so much about what happened to Maddie. And it just feels like more victimisation for this defence team to be doing this. This was a 13-year-old girl. Barely 13. She was only a few days past her birthday. She deserves to have her story told in full. And I'm sorry, but he deserves whatever is thrown at him. I will say, I do feel confident that since they are so heavily weighted on trying to avoid the death penalty, that says to me they know he's guilty and they know that he's not going to avoid a guilty verdict. And that they are basically scrambling to have that verdict as a life sentence and not as a death penalty. So I think we can take this as a good sign, but it is still so frustrating. So let me know in the comments section if you want me to continue wading through these motions in the way that I have been, or if you want me to just go through the titles of the motions and basically maybe the first paragraph or two to get the gist of them, and then we forget about them. I have quite a long list still of things that I want to look at in relation to Stefan, Jen, Chris Stearns. You know, some of the more person-oriented stuff, and I would like to get away from looking at these motions. So I'm curious to know what direction you would like me to take. If you also want me to go back to analysing things that have been said, looking at those sort of things, or if you're still keen for me to go through these motions. So, thanks for listening. If you are new to my channel, please subscribe. Also, please hit the like button, because right now I definitely need your help getting my videos back out into the algorithm. Seems that having had a bit of a break and then also being a bit sporadic with my uploads at the moment is having a major impact on my channel right now. So I need all the help I can from you guys to try and get back out there and get my videos seen. So please hit the like button. Please leave a comment. Thank you, and I'll catch you in the next one.
I've been to wonder